Thank you for tuning in for this legal update with myself, Sarah Sawyer, and my colleague, Scott Tippett, who is joining me, who is our expert on everything benefits related. So wanted to just give a legal update today on the Secure Act of 2022, so Secure 2.0 Act of 2022, which just went into effect and is really bringing sweeping changes to retirement savings plans. So I know I've been seeing it all over the place. It's been in the news. I've had, financial advisors reaching out to me. I've had clients reaching out to me, just asking, what's this about? And it's really, really packed full of a lot of goodies. So today, Scott and I wanted to just, kind of fill this recording to just get some of the top highlights out there for employers about some things they should be thinking about. And what are some things, Scott, that should be on everyone's radar?
Oh, there are so many things to choose from, Sarah. I don't even know where to start, but why don't we start with the expanded automatic enrollment in retirement plans? It used to be that employers could offer to part-time employees if they wanted to. Now that's going to become required. The automatic enrollment amount is going to be 3%, but not more than 10%. And it's going to increase by 1% a year until it hits 10 or 15%. Employees now have to opt out of the enrollment as opposed to opting in. And that's the first thing to sort of keep in mind. Current 401k and 403b plans are grandfathered, so that doesn't apply to them. And there is an exception for small businesses of 10 or fewer employees. A second thing, more of interest to owners of businesses, is going to be the increased age for mandatory distributions from IRAs. That age is slowly going to creep up to age 75. Beginning in 2023, it's going to be 73. Presently, it's 72. Or actually, not that we're in 2023, it's now 73. By 2033, it's going to be 75 years of age. So that if you're still working in the business and you don't need to tap your retirement, you don't have to, which lets it grow. In the case of traditional IRAs, tax deferred longer. In the case of Roth, just continue to grow. So again, if you don't have to tap it, you don't have to. That has the sort of added benefit of it lets it build up more so that if you need it later on for long-term medical care or something like that, you've got a greater amount to work with. One thing that may catch employers by surprise is the provision in Section 110, which now says that student loan payments will be treated as matching contributions by the employee. This is a very widespread and dramatic change. Up to this point, student loan payments, it didn't matter if you had them or not, they didn't count. Now, student loan payments can be counted as an employee's matching contribution for matching purposes from the employer. That will apply either to a 401k or 403b plan. It defines, qualified student loan payments very broadly. It can apply to about anything that is being repaid on account of education. So again, that's a very broad test. That'll go into effect for tax years beginning after this tax year. So beginning January 1st, 2024, that section will be effective. Another provision is a tax credit for military spouse retirement eligibility. The problem up to this point has been that given how frequently military members move, sometimes their spouses are not in one place or in one job long enough to have vesting. So now there is a credit provided if the employer offers a plan that gives the military spouse immediate vesting. They would have to be eligible for plan participation within 2 months of hire. Sometimes the waiting period is 90 days. They would have to be eligible for any non-elective contributions with at least 2 years of service, and the military spouse must be 100% vested immediately in all employer contributions. So some employers like to have cliff vesting, like you've got to be around for 3 years, before the contributions they've been making are vested on behalf of the employee. With this new provision, if it's offered and if you want the tax credit, the military spouse has to be immediately vested upon the employer contribution. The credit equals the sum of $200 per spouse and 100% of all employer contributions up to $300 for a maximum tax credit of $500. So again, it's not much, but it is something to help spouses of military members. Another thing.
And real quick on that, Scott, so on a couple of these, it sounds like there's going to be a lot of probably questions from employees coming from this. I know a ton of people's employees have, student loan payments that they're making and things like that. So it sounds like the kind of thing that, a lot of employees are going to have questions about. Employers are definitely, this just happened. So a lot of employers are trying to get up to speed themselves. From a timing perspective, kind of what do employers need to be considering as far as complying with mandatory things that are happening under this act and preparing for employee questions in that regard? Because I'm sure they're reading the same news articles we all are, right?
and that's I guess the good and the bad thing is there are a variety of different effective dates depending on which provision you're looking at. Some of them have got effective dates sooner rather than later. Some of them, the effective date is not until 2027. For example, elective deferrals for sales of S Corp stock to ESOPs. Other ones, though, given the sort of, I guess, the congressional intent to go ahead and try to benefit employees as much as possible, some are effective even this year. For example, the coverage now providing, the section providing improved coverage for part-time workers, that's going to go into effect immediately, and it reduces the 3-year rule to 2 years for plan years beginning after December 31st, 2024. So for plan years that begin January 1st, 2025, that'll be the rule. In this particular case, typically, again, employers could in the past make part-time employees eligible. Now they have to if they meet certain criteria. The part-time employee can either complete 1 year of service with 1,000 creditable hours or 3 consecutive years of service where the employee completes at least 500 hours of service each year. So it's an either or test, but if the part-time employee meets either of those, then the employer must cover the part-time employee under their plan.
It sounds like there's, and there always has been with these rules and anything having to do with benefits, right? It's a really heavy compliance area where it can be hard to be compliant. That's true with a lot of things involving employees, but especially in this area. And I know a lot of employers, they're going to be hearing from their insurance companies and benefits providers providing guidance. But just even from our talk today, I think it's really important for folks to get all of their advisors involved, just because there is so much there, and there's a lot of different deadlines. You've mentioned even just a few here. We've got grandfathering, we've got exceptions. As lawyers, we love exceptions. There's always an exception to the rule. But it's there's a lot there, and so I think it's I definitely would want to caution employers and companies from just kind of reading a newsletter that comes into their inbox and saying, like, oh, I understand what's going on with this. I think I know what I need to do. Or, oh, my benefits provider's given me some guidance on this. I think this is really an area where you need all of your advisors involved.
Oh, absolutely. Because, as with everything else that comes from the federal government, the devil is in the details. Treasury has not yet come out with the regulations that are going to implement some of these things, and that's where the real rubber will meet the road. But there are so many different deadlines and so many different pieces of it. I would be really reluctant to rely on just a bullet point sheet from a benefits provider or a carrier or anything like that. I think this is going to be the HR Employment Act for the next couple of years as HR departments start to immerse themselves in all these different changes, because some of the changes are optional. They give employers the option to do something, but many of them, such as the part-time coverage rule, is mandatory. And if they don't offer it, they will be out of compliance, and that creates all sorts of penalty issues.
Yeah, well, I think that's a really great point about the optional piece, because that really brings in also the strategy aspect of this. So some of it's compliance, and we deal with both. It's some of it's compliance, and we always want a bare minimum compliance, right? But then we can move into, once we get the bare minimums checked off, we can move into what's the strategic way to handle things, and whether it be as it relates to your employees or whether it relates to how you're running your business as the owner, in some of the ways that you mentioned. So I think then we start getting into the strategy buckets, and sometimes those meet each other as well. So
they do, yeah. And again, that's one of the great things about this is it gives a little bit to the employer and it gives some to the employees also, because again, changes such as raising the mandatory age for taking your required minimum distributions is going to be helpful to employers and to owners and senior management. They want to continue working into their 70s. They can do that. without having to tap into their IRA and start, paying additional taxes based on at least distributions from traditional IRAs. So it gives them planning opportunities as well.
Yeah, well, it's interesting. I mean, I think the student loan addition is a really interesting one. I know that one caught my attention, just kind of given the most workforces include a lot of different people on the spectrum as far as age and coming out of school versus being closer to retirement. And it seems like there's a little bit of something for everybody in this act for sure. So, well, awesome. Thank you, Scott. I really appreciate you walking us through all of these things. And, I think there's a lot to dig into here, and I'm sure this won't be the last time we're talking about this.
Well, Sarah, thank you. I appreciate the opportunity to talk to folks about these topics and give them a heads up as to what's coming down the pipe.
Yeah. Any closing words before we wrap up?
I would say, love your HR department because they're going to be dealing with a bunch of headaches. This starts to come out. But if you've got questions, that's what we're here for. We immerse ourselves in the law. We look for creative solutions to complex problems, and we're here to help. So reach out and give us a call.
I think that's a great point. Love your HR department. That sounds like that was our mantra during COVID as well, right? We're like, give everybody a good props on that, because that was like a new law school problem and equation every single day for your HR department. So that's great advice. So, well, thanks, Scott. Talk to you soon.
All right. Take care. Bye.